Afternoon, everyone. I am Lisa Messner, and this afternoon I am joined by my colleague, Chris Wager. And we are going to be talking about, you will see the cross out, the top 9 questions employers must answer before employees return to work. And I would be folly to say that it's even 9 questions at this point. You'll see at the end of our presentation today, we have some additional questions that were submitted by some of the attendees, as well as other issues as this topic develops that people are talking about. And so today we're going to try to cover as many of those topics as we can within the 30-minute time period we have. But I will just head off at the pass by saying that we probably won't be able to fully cover all of the issues surrounding this. And so would encourage you to reach out to either Chris or I after the conclusion of this presentation if you should have additional questions that are more tailored to your business or your circumstances. My name is Lisa Messner. I'm a partner and the litigation director with the law firm McMurray & Schuster, and I am joined with my colleague Chris Wager today. Thank you, Chris, for joining us and having this conversation with us today. We would not be diligent attorneys if we didn't start off with the disclaimer that, of course, the materials we're going to be covering today are meant for informational purposes to open a dialogue and get some issues in front of you to think about, but you should not take anything from this presentation as legal advice. That should be tailored to the specific circumstances or your specific business. So let's start with how did we get here? This is an interesting point because one of the first webinars that McMurray & Schuster provided was a discussion about switching to the remote workforce. And so one of our first conversations was, we're working remote and now what? And so now here we are a few weeks later and there's this discussion about the switch back. And how do we go back to reopening offices, reopening business? We know that states are announcing the reopening. We know that there's still public health concerns. And we know that for employers, in terms of returning to work, that it presents a myriad of issues. We have employees who are reluctant to return to work. We don't know how to treat employees who might be particularly vulnerable or susceptible to COVID-19. We have workplace standards to enforce and to be consistent with, and we still have employee issues that may give rise to discipline or issues associated with a reduction in force. So here today, we're going to talk about 9 critical questions that you should be able to develop answers to now so that you can be ready with a solid return to work plan. So question 1, when can employers require employees to return to work? And it's an interesting question because we hear a lot of conversation around the space that the new normal might involve some component of remote working. But there may be certain employees that are more efficient or a better value to an employer if they're on site. There may be employees who are just more productive and you would prefer to have them on site. And so when can you require those kinds of employees to return to work? So we know that this is state specific at this point. So Ohio is a case in point and that's our home state. And so what this state has announced is that on May 1, which is tomorrow, elective health procedures, dental services and veterinarians are allowed to open fully. Going on to May 4th, manufacturing, distributing, construction, and general business offices are permitted to open. And then May 12th, we're going to see consumer and retail services. So these are all going to be subject to precautions that are put in place intended to spread the COVID-19 virus. And I'll talk a little bit more about that in a moment. But it's interesting because I do think that we will see a lot of states do this kind of tiered approach to reopening business. And I also think we'll see some states like Florida doing things where they are making more specific county-wide restrictions. And so, for example, Florida has announced its reopening, and even allowing some restaurants to open at a 25% capacity, allowing outside seating at restaurants to be permitted if there is adequate 6-foot spacing in between the seating areas. But Florida's opening excluded Miami-Dade, Broward County, and Palm Beach County. And so you see that counties that are specifically afflicted with this are being accounted for in the state-specific plan. We know that Tennessee opened restaurants, and we know that Tennessee had a high spike, in connection with cases. And then we saw that Georgia opened fully, just indicating that if businesses wish to open, that they could. And the net result of that was that a lot of businesses didn't, because they just simply weren't prepared. They didn't have these kinds of things in place. And so that is why we have to have this conversation now and plan for it now. It's a double-edged sword for employers, because employees could be upset to be brought back to work. They could have fear over the virus. They could have fear maybe because they have a loved one in their home that is particularly susceptible to high risk associated with this virus. You have employees who are upset not to be working. It is financially impacting their staff. And so, one thing that we can consider is a voluntary start if we're not at 100% capacity. We have to think about what that's going to look like, because I think that the inclination in what we're hearing from our clients is to implement some kind of protocol intended to protect employees, particularly at high risk. But we have to be very careful in how we do this, because as an employer, you can't simply state something to the effect of, the workforce can come back unless you're over the age of 60, you should continue to self-quarantine. That's going to open up a problem from, a possible age discrimination type of perspective. That would be true also if employees with certain medical risk factors known to the employer are excluded. And so we have to be thoughtful if we're going to have a kind of a voluntary start, or if we're going to make it open for our employees to elect to continue to be on some kind of leave due to a high-risk category they're in. I would recommend that we couch that in terms of an accommodation or some kind of voluntary option for the employee, and not to just do it systemically across the board to avoid those kinds of issues. And so, what additional measures for employers should we be looking at to mitigate the spread of COVID-19, right? This is the stuff we've talked about all along. Some of these things in your state may be recommended but not required. Some of the states may require them. I'm hearing word that some states are even requiring more county-specific things. So you're going to need to really take a look at what the recommendations for your area are. But we kind of know some of the CDC guidelines, right? Masks and 6 feet of physical distancing, frequent cleaning and sanitizing. If gloves are available and employees are handling large, like in manufacturing surfaces where there's metal, where they believe that this virus can thrive for a period of time, gloves should be available. Frequent opportunities to wash hands, hand sanitizers. Another good practice would be to stagger breaks, so that you don't have a large volume of employees in any one particular break area at any one time. Daily wellness checks can be provided for employees. We're going to talk a little bit more about that later, but that is going to raise some issues in terms of privacy, HIPAA, and it being a medical screen under the ADA. So we want to be careful with those kinds of things, but I do think that is going to be something that's going to be very important for the employees to have some degree of insurances. If we can allow employees to work from home, that is a good option for the time being. And then, to limit the number of physical persons inside the business. And so this should, target, in addition to potential clientele or customers, thinking about vendors and things of those natures. And so with that, I am going to hand it over to Chris to talk a little bit about monitoring employees for symptoms.
Hello, good afternoon or good morning, everyone. Thank you, Lisa. This is actually the perfect time to kick it back to me because my 1-year-old, who's a couple rooms over, just fell asleep and stopped crying. So you don't have to listen to that in the background. So that's great for everyone here. Piggybacking on what Lisa just talked about, a common theme of what I'll be talking about on these topics is the importance to proactively set these standards that we're talking about in written policies. So kind of an answer to question 2 that Lisa talked about the different safety standards that you're going to implement. For example, what's important is to be ahead of this and to think about your specific business and what safety measures you need to put in place. We've heard anecdotally, right now in many states, kind of essential businesses are open and kind of under the purview of local health departments. And what we're hearing is both employees and other individuals have been complaining that employers are not adequately putting safeguards in place, and local health boards, what they've been doing is generally speaking, requesting copies of the written policies that these businesses have in place. So that's really the first step that's important to ensure compliance. And as we move forward, we're sure that OSHA and other regulators will be taking a similar approach, where that's your first line of defense, is having fulsome and adequate written policies in place. Okay, now getting back. Question 3, talking about screening employees. As I'm sure everybody has heard of, the real kind of, unfortunately, with the non-availability of testing now, the gold standard for screening are temperature checks. And this is going to vary state by state, but the good news is that there is some degree of protection for employers because the EEOC has already come out and affirmatively stating that temperature checks and temperature screening is appropriate. A number of states are either mandating or recommending that employers conduct temperature checks in advance of each shift. It's to varying degrees, but I just kind of have a non-exhaustive list right now where we've got Alaska, Delaware, Colorado, Michigan, Texas, Vermont, West Virginia, and yes, even Georgia is to some level requiring that employers conduct temperature screening for their employees. Now, what's important for temperature check screenings is, and that's whether you are an employer conducting it yourself as the employees come to work. The other option that's not as good of an option is to kind of operate on the honor system, where you require employees to check their temperature before coming to work. But what's most important is to set a written policy. What is the screening threshold? The CDC recommends 104.4 degrees is the kind of the symptomatic level of fever that you should be targeting. And setting what the rules are to return to work. Does someone have to, following CD standards, have 2 negative tests? Is there a time period after a positive test? Because if someone does come in with a fever, clearly the answer is going to be to send them home and not allow them to be in the workplace. So having that written policy is important, and that policy needs to be communicated to the employees in advance so that employees don't have any surprises when they come in and have 101 degree temperature about what that means. Now, when you do these temperature checks, there's no requirement to create a log or a record of the employees and what the temperature checks are. However, if you do create these records, please remember that any records about employee temperature is health information that's confidential and protected under the ADA and potentially state law. As I mentioned earlier, kind of swab testing is going to be the gold standard going forward. Hopefully the testing capacity is get there, and that can both be testing for positive and testing employees for antibodies. At this point, it's a moving target. Nobody knows if a positive antibody test means you're immune, but we'll have to keep an eye on that development and what that will mean for employers. Lastly, with temperature checks, something to keep in mind is there may be a backup. There could be employees waiting 15 minutes in line, 6 feet apart, properly socially distanced for those temperature checks. In all likelihood, the time that employee is spending undergoing those temperature checks is likely connected to work. So if you have an hourly employee who is non-exempt, you have to keep that in mind and make sure that they're being properly credited for that time where they're undergoing the screening. The next topic is, what are the employer's obligations if an employee contracts COVID-19 upon returning to work. And that can be either, we should keep in mind, considering contracting COVID, that can either be a positive test, but if an employee becomes symptomatic, really at this point, the best course of action is to treat, such as elevated fever, coughing, to treat those symptoms as if the employee is afflicted by the disease. Now, some changes now that we have are with respect to FMLA and sick leave. The Family First Act, which just passed at the beginning of this month, now requires employers to provide 80 hours of paid sick leave. Now, it's important to, when looking at this, it's both for employees that have COVID-19 symptoms or if an employee is caring for an affected individual. That doesn't even have to be a relative. And there's a long list of other covered instances. So it's really important to take a broad approach if an employee is affected either directly or indirected through this illness to ensure whether or not that employee is entitled to the 80 hours of leave. And for example, even if nobody is afflicted, but the employee's child care options are now out the window because the daycare is closed, for instance, that is another allowable exemption that allows the employee to take up to 2 weeks or 80 hours of paid sick leave. In addition to the sick leave, the Family First Act has expanded FMLA leave. Whereas before you were looking at FMLA, an employee had to work 1,250 hours over the previous 12 months. Now, under the new act and the expanded leave, an employee only has to have worked 30 days prior for that employer. In addition now, and this is after the 2 weeks of paid sick leave kick in, employers are also responsible for 2/3 of the employee's wages during this 12-week period for an amount up to $10,000. So now we're looking at, this isn't unpaid leave, but rather kind of partially paid leave. The act, the employers do have some recourse where they can get tax credits or other funding available to offset these costs for the expanded federal benefits. In addition, we'd advise you to consider other state law benefits or state law protections that apply for allowing leave for those employees. And again, I mentioned this a little bit earlier, but when you do have an employee who either tested positive or was symptomatic, there are CDC guidelines in place. These should be treated as a minimum standard. Different states have adopted more stringent standards on when an employee is required to go to work, but the minimum set forth by the CDC, so for a employee who tested positive, 72 hours to 3 days after their fever subsides and 7 days since the onset of symptoms is when, according to the CDC, an employee is able to return to work. Now, as we're hearing, a lot of individuals are asymptomatic. So if an asymptomatic individual, sorry, Lisa, if you don't mind.
Sorry about that.
No problem. For asymptomatic employees, clearly they're going to find out that they were carriers based on a positive test. There would be 7 days following their first positive test is when the CDC states that employee would be cleared to work. In the absence of a test, but someone had a relative or knew that they were exposed, that should be treated 14 days following a known exposure. And as I mentioned that last bullet point there, please check to see if your state or locality has implemented more specific rules. Okay, at least you can go.
Sure. So one of the things that we had been thinking about and added to our list today was an issue that we are hearing from people in terms of self-quarantining. So if we have an employee who has voluntarily traveled or had to travel for some other reason, maybe to an area that is known to be highly afflicted, certain parts of New York, Florida, etc., can the employer require that employee to self-quarantine for a period of time before returning to work? And so I think that the answer is not completely clear here, but the best practice probably would be for the employer to request some kind of voluntary self-quarantine. I do think that's going to implicate some additional leave requirements, and that's going to go back to Chris's point about making sure that we're documenting consistency within our policies, procedures, how we are looking at those things, so that there is not any kind of issue where the amendments to the FMLA are violated because the leave was not extended. Another question is, and this has come up particularly with clients of ours, is how do employers respond to an employee who is refusing to turn to work, and they're basing that on a fear of contracting the virus or due to a lack of childcare? And those are very real concerns for our employees. We have to expect that these issues are going to arise, and we have to plan for them. And it is so necessary to have policies and procedures documented in place so that we are making sure we are complying with the law. The law is changing. You know, as this pandemic occurs, there were very marked amendments to the FMLA and the ADA to account for these things. And so, terminating an employee for reasons that are related to their concern about their health can be very problematic. So think about how you want to handle that and how it will be addressed. Specifically, what if it even is more tangential than that, and you get a complaint or a concern from an employee who doesn't want to return to work because they have someone in their household who is in a sensitive category to COVID-19. There are a lot of different laws to consider, and so again, I would just encourage you that if you have specific issues around this, that you should target your procedures and documented policies specific to your business and specific to the size of your business. And so happy to talk with anybody more fully after the seminar today on those issues. But here you'll see quickly there's a lot of employment laws. We're talking like ADA, potentially Title VII. You've got the CARES Act and the Family First Coronavirus Act. And these are all new things, and the law around them is changing very rapidly. So just make sure you're staying buttoned up on that side. Another issue that is raised is what happens if an employer needs to reduce their workforce due to loss of business, which businesses are contemplating is going to happen. How do you do that? How can you make sure that the reduction is implemented fairly and lawfully? So it just goes back to the best practices always when a reduction in force is necessary. It should be done by measurable, objective standards. There should be a specific accountability to not overstep anything that would implicate the FMLA and ADA, and that's a particularly sensitive topic in the COVID-19 era. But it should be based on measurable standards, such as length of service or some kind of quantifiable performance indicator, and that should be measurable and documented. You should take a look at any kind of reduction of force across the board to make sure that there's not a discriminatory impact. Make sure that there's no particular protected group targeted. You should be making sure to pay particular attention to any kind of employee complaining about concerns over the COVID-19 crisis, and any kind of action that could be considered retaliatory. It not only triggers Title VII issues, it triggers issues that I think we will see crop up in the states over terms of terminations or adverse actions that are connected to a violation of public policy. I think that when we have a national healthcare crisis on our hands, public policy is absolutely implemented, and many of the states do recognize individual causes of action for any kind of workplace conduct that is in retaliation of some kind of public policy measure. And then question 8 was, how should an employer handle an employee's complaint to an agency, the Department of Labor or Department of Public Health, either at the state level, federal level? contemplate that what employers will see as they're bringing their employees back to work, that if there is that resistance to return over a concern about exposure to the virus, that we will see a spike in regulatory complaints. And so it's particularly important for employers to contemplate and plan for a response to employees' complaints, to have something in place in terms of the safety measures that are being provided, so that can all be outlined in a kind of formulaic response. It is critically important to maintain good government relationships. It benefits employers in multiple ways. It benefits the employers in multiple ways. It allows an engagement with the regulators to get guidance, to make sure that proper mitigation efforts are being done, and to document and confirm that you are in fact doing those things. And last question, I had that off at the pass, and that Chris and I, again, as these issues continue to develop, came up with a few more things to touch on quickly at the end here. But how do I handle employee discipline? This is one we get, and terminations for cause during the COVID-19 crisis. There's, concern about a lot of employment laws being implicated and not wanting to have the appearance of impropriety in violating those. So just be mindful that you retain your full right to discipline and terminate employees for cause, insubordination, failure to meet, objective performance indicators, things of those natures. The best thing to do here is just have your terminations supported by written company policies. Document regularly and do progressive discipline for any kind of failure to meet performance objectives, and make sure that if you have any question or concern about whether you are properly documenting those things and properly communicating those types of things to employees, that you're maybe running it by counsel just to get a second set of eyes on it. So with that, as I had mentioned, Chris and I had talked about additional challenges and additional questions, and so we wanted to kind of touch on a couple of other things quickly. We may go over just a few minutes, but we'll try to button up here in the next 5 minutes or so that we don't hold anybody past the time that they planned on. But just would briefly like to touch on some other issues in terms of best practices for reopening call centers. Large versus small organization challenges. What does that look like if you are in multi-location? And so my personal thought is that, practices for a large call center versus a small office with 5 people are going to have to be tailored to the needs of that business and the volume of your employees. I think you're also going to have to consider the multi-location issue in terms of if you have employees traveling interstate, if you're on a state line, because the requirements might be different, and then you're going to need to look at the requirements of both of those states. And then how to look at it if it's county specific, where we know that in some of the states it is. Again, same premise applies. I think you're going to have to look county by county on those things. Chris, did you have anything to weigh in on these 2 additional challenges that have been identified?
No, I really just do think that this is showing that we're in extraordinary times right now, and every business and every industry and every jurisdiction is going to be different, and it's just important to, really have a thoughtful, personalized approach. This can't be one size fits all, and the first and foremost, the concern really has to be your employees and their health, and being sure that anything you do, you're able to do it safely and to the best extent possible to keep your employees safe. I
agree. And so we close today by just elucidating the issue we started with. I am sure that the things we've talked through today probably raised even more and more questions. And the reason that our last slide is more and more questions is because as Chris and I talked through these issues, we identified more and more issues. And so there's going to be more and more questions and more issues. And I would encourage you to seek out counsel, there's a lot of publicly available articles and guidance and information and thought leadership on this. So just stay atop of those things. And as you identify issues, do not hesitate to reach out to Chris and I to discuss those things and help you make a plan for your business that makes sense. And so with that, our questions were, which workers qualify to continue to work remotely? You probably want to have that in some kind of documented fashion on which one and under what circumstances is remote working available. It's a privilege, it's not a right. Can employees double dip on sick leave? This is one that I think that the law is not completely clear on, because there are different circumstances under those amendments to the FMLA under which the 80 hours of leave is permitted, but the regulations suggest that there's not going to be a double dip permitted there. If an employee displays symptoms, is this an event requiring notice under the FMLA? Because the sick leave is an amendment to the FMLA, I would say that it is, and the best practice there would to go ahead and notify your employee. And then lastly, I will pass this back to Chris, because this was a specific issue that Chris had raised, but if an employee's duties change over time, what impact does that have on their exempt versus non-exempt status?
Yep, yeah, exactly, Lisa. I mean, we're seeing, businesses are fundamentally changing. People are moving. Someone could have been going from door-to-door sales. Now they're doing telephone sales. Job responsibilities are necessarily changing. So you both have to think under the FMLA, what does that mean about exempt status? And to another degree as well, to the extent you have employees with accommodations under the ADA, are there fundamental work requirements changing where you have to reevaluate the accommodations that are provided to those employees? So these are all questions that we know employers are dealing with now.
All right, and so with that, we want to be mindful of everyone's time. So we will wrap up. We'll say thank you so much for joining us today and having this very interesting conversation. Happy to help serve as a resource for you as we go through these trying times and start to reopen business. And so with that, we'll just make you aware that our webinar series continues next Thursday. Chris, I believe you are involved in that one, so I would invite you to give a little preview to our audience for that.
Of course, very quickly, we are going to be presenting on biometric information privacy laws. It'll be hosted by me and Michelle Schuster. If you're an employer, if you have timekeeping software where employees use a fingerprint or a hand scan to clock in and out of work, this is something that will be definitely important for you. We're seeing a number of class action lawsuits resulting from this, so it's definitely a new, hot, and important topic.
Right. Thank you, everyone. We hope you enjoyed our presentation today.